So we have the pleasure now to open this part dealing with the ELI project on fundamental and constitutional principles. You may remember that we had previously a project on common constitutional tradition, where we had the project that is now finished on freedom of speech, and here it's a different perspective. Of course, when one looks at the definition of these fundamental constitutional principles, one sees that it is difficult to identify exactly what are these core fundamental principles, and also how to give guidance so that these evolve in a certain way. And so I'm really happy to have a wonderful panel today to look into that project. Of course, on the one hand, we have Takis Tridimas, who is the project's co-reporter, but then we have also other perspective. And I'm really happy that we have Ralf Kessner, Head of Unit for Fundamental Rights and Values and Rule of Law, a long title because he does a lot of things, for the Council of the EU. And so that will be the perspective of the EU, but now from the Council perspective, we had this morning several times the Commission perspective, so it's a slightly different perspective with also different interest maybe to some extent, so I think that will be very interesting. And then online we have Pauline Costello, judge at the European Court of Human Rights, and of course when one speaks about fundamental constitutional principles, one thinks also at the European Court of Human Rights. And then, last but not least, we have Katarzyna Rzekowska-Korzłowska. Are you really speaking Polish? Because maybe it was not perfect, I'm sorry. But she's director of the Poznan Human Rights Center of the Institute of Law Studies of the Polish Academy of Sciences, and she will give us also some reflections on this. But let's start immediately, because we started already a bit late, with a presentation setting the scene, so to say, and the aim of this project. I give the floor to Takis Tridimas. He's chair of European law at the Deacon's Pool School of Law, King's College in London. Takis, you have the floor.
Thank you very much. It is a great honor to be co-reporter for this project. I am very grateful to the European Law Institute for entrusting the team with carrying it out and for all the support that they have offered throughout. So what I was going to do is say a few words about the project, what it is about, and then zoom into some principles and share with you the doubts of the team, as it were. This is a project about fundamental constitutional principles, and principles have a certain beauty, but also a certain drawback. And the beauty is that they operate at a level of abstraction which facilitates political consensus. We all agree that freedom of expression is a great thing. We all agree that the right to due process and judicial protection is a great thing, but not all of us derive the same outcome from these principles. So we need intermediaries, we need agents to make the transition from the principle to an outcome. And this is where process comes in, this is where the judiciary comes in. So one of the challenges of this project is to identify what is the suitable level of specificity, because we want to be all-embracing, we want to provide principles that can be transposed in different ways within a broad, acceptable variation, but on the other hand, we want to be useful. Secondly, these are constitutional principles. That means essentially that they pertain to the way political power is exercised, and they also pertain to the rights of the individual. They have an overarching character in the legal system. And that also brings me to the final attribute. They are fundamental, they stand at the apex, and we also think that they should have some heightened legal force. I will come back to this issue. So objectives and rationale, why are we doing this? Well, a senator in the United States was reported in the New York Times as stating recently that democracy is a very unnatural regime. And I think he has a point. Essentially, it is correct to say that historical experience suggests that regression is possible. The ideals of democracy require vigilance. Also, there are contemporary challenges. I have looked at some empirical work. One world data is one independent group that rates democracies. Other groups do the same, but they all come using somewhat different methodologies to the conclusion that there has been a regression. There are fewer, as it were, democracies now than there were, or at least liberal democracies, than there were 10 or 15 years ago. So we group principles under the following headings. Principles of liberal democracy. I'm not going to go through them. I think the PowerPoint is just to give you the structure of the project. Rule of law is another cluster. Judicial independence is a separate cluster, although, of course, a basic perusal of these headings suffices to show that there is a great deal of overlap. And there is a good reason for that, that all these principles are part of a system of governance. We think judicial independence is such an important aspect of the rule of law and of liberal democracy more generally that it ought to have its own a separate cluster. Then we move to checks and balances and accountability, dignity and equality, protection of fundamental rights, but we do not intend to go through all fundamental rights. In fact, we as the project stands at the moment, it provides for a general commitment to the rights enshrined in the European Convention, and then refers specifically to the right to environmental protection and the right to asylum. So there is some selectivity there which we try to defend. And finally, there is a cluster of constitutional integrity which provides, if you wish, horizontal provisions, some guidance on limits to states of emergency, the prohibition of abuse of rights, entrenchment, and so on and so forth. So, what are the salient points of these principles? As I said, they pertain both to political governance and to the rights of the individual. They refer to both process and substance. They are closely intertwined and they must be taken as a coherent whole. The project is both descriptive and prescriptive. We are not looking on a comparative basis at all the laws of the European states. We try to make a synthesis looking selectively at the laws of certain jurisdictions and, of course, the case law of the European Court of Justice and the European Court of Human Rights. The drafting is not intended to replicate the drafting of a treaty or a constitution. Some provisions, some principles have been drafted in that, with that in mind. Others are more aspirational, more loosely drafted. So this is principle one, and I'll take you through two principles only, because I only have 2 minutes. So principle one, values, and we already have controversy here because we use the term a liberal democracy, values of a liberal democracy. And what does liberal mean? Well, it is not intended to be partisan. It contrasts with electoral democracy, and essentially what is meant by it is a political regime that respects political pluralism. That is to say, it accepts multiple sources of authority in political, social, and economic life. It recognizes that multiple values need to be balanced and is based on expressive liberty. I borrow here terms from Professor Carlston and indeed Isaac Berlin. The idea is that the individual is at the center of the legal system. So that results in the recognition of certain counter-majoritarian values, the idea that there have to be some fundamental rights. I would leave it up to you to study the PowerPoints, and I will take you right to the end of it, because that has also created a controversy, and the group has labeled over that. Should we, is it a constitutional principle that the principles that protect fundamental rights should have some kind of entrenchment? In other words, heightened legal value. What is this heightened legal value? Of course, they have interpretational force. The other rules of the legal system must be interpreted in their light. There is a plethora of case law here from English courts, the US Supreme Court, European courts. So that's not controversial. The second point is, well, we think that there has to be also some kind of a constitutionality review, but we understand this very loosely. I think there are many ways of the courts assessing the compatibility of measures, including legislation, with constitutional imperatives. There doesn't need to be a constitutional review in the way we understand it in Germany. It could be the system followed in the United Kingdom by the Human Rights Act. It could be the Canadian system, which is somewhat different. The third point is entrenchment. Is it acceptable for the majority to be able to do away with these constitutional rights? Or do we accept that there has to be some degree of strictness in the constitutional fundamentals? The issue is controversial. The United Kingdom is undoubtedly a liberal democracy. It's a leading one, and yet it doesn't provide for this kind of checks and balances. On the other hand, I think the logical consequence of accepting that the majority must be bound by certain rights is to accept that the majority itself cannot unbind itself. And it is really the Ulysses example. When Ulysses goes through the sirens, he orders his sailors to tie him to the mast because he wants to listen, but he knows the risk. He knows the risk, and says, whatever no matter how much I cry, don't untie me. And that is essentially what the majorities do in a constitutional text. They bind themselves. It would make very little sense if Ulysses could untie himself, yeah, and then the order to the sailors would have no meaning at all. But that's the sort of one aspect of, if you wish, horizontal controversy, not in relation to a specific principle that arises. I'm very happy to comment on specific principles during the discussion. Thank you very much.
Thank you very much, Takis, for this very short overview, of course, because you had only a couple of minutes. But I never thought of tying Homerus and the fundamental constitutional principles. I think that's quite an interesting idea also. And thank you for coming with that picture as well. We have now the great privilege and pleasure to have with us Pauline Koskelo. She's a judge at the European Court of Human Rights, and she was a president of the Supreme Court of Finland until 2015. And of course, in that position, she had already to look into fundamental constitutional principles from a Finnish perspective, if I may say so, and then at the European Court of Human Rights from a larger perspective as well. And so she told us that she would now look at gaps and difficulties, and so we are really thrilled to listen to her. welcome to you.
Thank you very much. Can you hear me?
Yeah, perfectly.
Yes,
Thank you very much.
Thank you very much. So thank you very much for giving me this opportunity to discuss this important, very timely and very topical project. And I'm very sorry for not being with you there on location. Now, many of the constitutional principles of a liberal democracy are rather obvious in many ways by now, but they do also involve many specific and quite complex issues. So to articulate the basic principles in a concise but meaningful manner is quite a demanding task and requires careful reflection and drafting. And I would like to give some remarks on the current text, underlining the fact that, of course, my remarks are in a personal capacity. Although in my current job, I have to say that I see very well that the concerns we have at the present are real and serious, and at times it feels like what we see in Strasbourg is a kind of a horror landscape, which is often quite not just worrying but even depressing. So going back to our topic today, I would say at first that as far as the overall structure of the document is concerned, I mean, the main chapters and headings of the principles, I think the draft is quite well structured. There is perhaps more to discuss regarding, obviously, the formulation of some of the sub-principles. We should end up with a coherent and analytically robust whole, bearing in mind that the ambition is to formulate sort of a sine qua non elements of liberal democracy, not less, but also not more. There is a lot in the draft that is really fine, but in the very short time that is available, I feel that I have to focus my remarks on some of the points that would seem to call for some further elaboration. And I apologize if this will sound a bit like a listing of various items, but it comes with the nature of the subject. Firstly, Principle 2 has the heading Representative Democracy. Here, the second paragraph states that the principal legislative function is exercised by Parliament. But what it fails to mention is that Parliament must be a body composed through elections. Yet this is the essence of representative democracy. So it seems that there's perhaps a key link between Principles 2 and 3 that is currently missing. Principle 3 deals with elections, and this is all fine, but the right to elections has two basic components: the right to vote and the right to stand for election. And for instance, in the European Convention, both are covered. But the latter, the right to stand for election, is not addressed in the current text, and I think that it should perhaps not be forgotten here. The principle we have here in Principle 3 is linked with Principle 2, that is to say, elections in the context of representative democracy. The issue of referenda is raised in the comments, but I think this is a separate matter because referenda might actually be instrumentalized to undermine or circumvent the representative democracy. So this would be quite a tricky subject to address, but if addressed, I think it would not be appropriate to do so in the context of Principle 3. Then I move on to principle 6, which deals with disinformation. I think it's really good that this increasingly serious threat to democracy is addressed. But there is perhaps yet another partly similar but partly different phenomenon around these days. And that consists of smear campaigns against those expressing critical views. If disinformation is about distorting the message, this other phenomenon is more about destroying the messenger whose message is disliked. Such practices we see in various parts of Europe, for instance, by pro-government media against critics, and these practices can come pretty close to persecution. So this problem is perhaps also something worth considering. It's all about, say, killing rational debate, which is the bedrock of a democracy. I've just recently written a separate opinion about this matter in a Serbian case. Then moving on to part 2, rule of law. I think the contribution of the Venice Commission should be noted here, especially the checklist they adopted some years ago, because this document is something which the European institutions have relied on, and it clearly shows that the current mainstream European notion of the rule of law is not just formal, but substantive. Then, as regards principle 8, dealing with the requirement of legality as an element of the rule of law, here it seems to me that the formulation of paragraph 1 is somehow circular because it refers back to the rule of law itself. Whereas the essence of the legality principle is that the exercise of public power is subject to the law. This is the general requirement of lawfulness as we see it in several convention provisions, for instance. And I think this should be set out accordingly. And also I think it's worth noting that the principle of legality as a general component of the rule of law is broader and is distinct from the principle of legality in the context of criminal law, Article 7 of the convention, for instance. So the two are related, but they are not to be confused. Then I quickly move on to principle 9, which deals with legal certainty. This is now limited to the legislative aspect, but there's another key element of legal certainty which seems to be missing, and that is the principle that final judicial decisions should remain final unless exceptional grounds justify the reopening of a case. So this second aspect of legal certainty, on which we have a lot of case law, should I think be addressed as well, probably in a separate provision. Then I hasten to move on to principle 15, which talks about judicial independence and impartiality. There in paragraph 3, there is reference to freedom from external orders and instructions, which to me appears a bit too narrow because I think that any undue pressure or influence should be excluded, and this should perhaps be reflected in the text. Then, as regards the specific guarantees of independence in principle 17, the focus is very much on the position of individual judges. But I think that attention should also be given to the protection of institutional independence within the judiciary, including the provision also of adequate resources, etc., because there are many ways in which judicial independence can be undermined other than attacks on individual judges. Then principle 19, which deals with the separation of powers. Here it strikes me that paragraph 2 lists the powers of parliament and states that the parliament is responsible for controlling public finances. Now, this terminology seems to me a bit inadequate because the parliament is there to exercise budgetary powers by determining ex ante the forms and levels of taxation, the income side, and by authorizing the main points of state expenditure. So this phrase there, controlling public finances, seems more to refer to the ex post control of finances, which is a distinct matter. So perhaps this principle is a bit too narrow here. Then, as regards accountability, which is addressed in principle 20, this I find somewhat problematic in various respects, both regarding the notion itself and the scope. I think perhaps a better analysis would be needed here, because in one sense, accountability is a corollary of the principle of legality. If there are unlawful acts, they must be accompanied with mechanisms for sanctions, and this also concerns individual office holders and not just entities. And obviously for the highest holders of public office, both legal and political accountability may be applicable. In another sense, the actions of public authorities must be subject to scrutiny from the point of view of policies, as well as from the point of view of legal and financial compliance, and the scrutiny then, of course, may give rise to other consequences, sanctions, etc. So it seems to me that all this should be perhaps more clearly set out. And there's another problem here in the current text, because accountability is said to apply to all those who exercise public functions, so all branches of government, including the judiciary, that is. And according to the text, all these should be subject to political, judicial, and financial accountability. But obviously, however, it cannot be suggested that the judicial branch should be subject to political accountability. So I think there are distinctions here that should be better made out. Then finally, a few words on the protection of fundamental rights. There are a series of issues here. First, I wonder whether it's consistent with the sine qua non nature of the principles to suggest that compliance with the European Social Charter is an indispensable requirement, without which a polity cannot qualify as a liberal democracy. Question mark. Principle 27, first of all, has, I think, a strange title, because the core issue is not about the applicability of fundamental rights to private parties, but on the contrary, the applicability of the obligations arising from the rights for private parties. As regards the substance, here I have some difficulties. Paragraph 1, the last sentence might even amount to a restriction of the state's positive obligations, because it only refers to serious threats. And paragraph 3 also appears to somehow confuse the power of the state to regulate private activity, which obviously is not limited to parties whose activities impact on core elements of a liberal democracy. And the question of whether fundamental rights can produce direct horizontal effects without a legal basis. Now, to the extent that this latter is intended, I think we clearly would end up in a tension with some of the other basic principles, in particular the principles of legality and legal certainty.
Just,
So,
Judge Costello, if I
yes,
could ask you to come to an end because we still
yes,
have
I
a couple
will.
of interventions.
Yes,
Thank
I
you very
will.
much. Sorry.
So in my view, it should be made clear that the horizontal effect operates indirectly through the positive obligations of the state. Then as a final remark, Principle 28 addresses environmental protection. But this is not formulated as a fundamental right, is formulated as a general state, as a matter of general state obligations. So in conceptual terms, as it is set out, it does not really sit well under the heading of protection of fundamental rights. But in substance, of course, the big question is to what extent the obligations of the state relating to environmental protection and sustainable development entail individually justiciable rights. And these are, of course, highly complex issues, including from the point of view of the separation of powers. In our court, we currently have several pending cases which raise such issues regarding climate change, etc. And I will refrain from saying anything more than to point out that the intentions and implications of the current draft in this regard are, I think, rather unclear. Then finally, as regards Principle 33, the issue of entrenchment, I think that this is indeed a very important issue, and the current developments show that it's really worth discussing the question whether there should be some sort of an eternity clause in constitutions like they have in the German constitution. So I know my time is up, and I will stop here and just thank you for all the work that has been done, and I hope that these comments might be helpful in the further work, and that ELI will arrive at a high quality document on this important subject. Thank you very much for your attention.
Thank you very much for this. Yeah. Thank you very much for this very astute analysis of this work in progress. And as Takis Tridimas mentioned, the object is not to write a new constitution, even though he comes from a country where there is no written constitution. At least that's what we say usually. And indeed, all these remarks are very important. We see also through the remarks that the ELI has some projects that relate to some of the provisions, and of course we will not integrate all the other projects into this project, if I may say so, and that explains also some of the aspects. But thank you very much. I have now the pleasure to pass the floor to Katarzyna Szekowska-Kurzowska, more or less. And she will make a specific comment on one provision, Article 25, on non-discrimination, in particular in gender perspective. You're welcome. The floor is yours.
Thank you very much. Thank you for inviting me, and I would like to congratulate this very ambitious and I believe very important project. And this is my first ELI conference, and I really like it, and so hope not the last one. So I would like to comment just on a very small piece of the whole project, and to give some my insights into it, coming also from my experience, who I am and where I come from. So I have just short 4 points that I would like to discuss. The provisions are here. They are much alike as the EU Charter of Fundamental Rights provision on equality and non-discrimination, and of course these are one of core constitutional principles. So my first question, my point for discussion is So we're a woman. So of course there is a provision of anti-discrimination based on sex, which covers women. But on the other hand, in many human rights treaties and constitutions, we have this special equal provisions on equality of men and women. Of course, we can ask what is added value to the simple ban of discrimination. So in my opinion, there is added value, and here I refer to treaties as international covenants on political human rights and of course the international covenant on economic, social and cultural rights. I also refer to EU Charter, but also to country constitutions like Polish, for instance. So I think that it's still important to include provisions on equality between men and women, especially because we are facing backlash, and the backlash against women's rights, feminist rights, also LGBT plus rights, I will refer to it afterwards. It's really underpins illiberal tendency, things that are done by populist governments in Poland, Hungary, but also in other countries. So I think that we cannot leave these topics behind the core discourse on constitutional rights. So that is why I think that this perspective should be included. If we read the comments to the project, and we have references there to many international treaties, including, for instance, Istanbul Convention on Violence Against Women, what I think is really important. But on the other hand, there is, for instance, nothing about CEDAW Convention, the Convention on Elimination of All Forms of Discrimination Against Women. I think that this part of heritage that still be constantly involved in discussion about constitutional principles. But of course there is another side of this coin, because if I talk about equality between men and women, we are still in good traditional binary world. But of course it comes more into gender topics. So what about gender? Here of course we have prohibition of discrimination based on sex and also on sexual orientation. So as it comes to the interpretation of the European Court of Justice, the Court of Justice of the European Union, it seems to cover more or less the spectrum of the problems, let's say the problems with realization of human rights for LGBT plus people that we have nowadays. But on the other hand, there is a clear lacuna here with the lack of gender identity. I mean, all this sphere of realization of rights of non-binary persons, or all these persons who suffer discrimination because of their gender performance, intersex people. So here I think that in this kind of thinking about non-discrimination, we should be as much progressive as we can, and since the project is of perspective value and you know, pushing some new perspectives, I think that including gender identity issue inside of the non-discrimination principle would add important value to this ideas that are behind. The fourth issue is, and here is of course much to be underlined, that this is of course a non-closed, non-exhaustive list of protected grounds. So of course if I refer to gender identity, I know that it is there because it can be interpreted from this provision. So this is of course very important to have this in mind, and the wording of this provision is quite clear, and what I really like, that it's really rich in as for the identities and features that are protected. So this is a very important value of this provision. And my last comment is about proactive approach, which is clearly visible in the comments, but I think that it could be still more elaborated in the principles itself. I mean that, of course, when we talk about ban of discrimination, it's not only about negative side of non-discrimination and not discriminating people, but of course about ensuring substantive equality, that everyone can realize, can achieve her or his rights without discrimination on equal basis with others. How to do so? That's the challenge. So here comes the whole spectrum of proactive measures. So the measures that I borrow vocabulary from Sandra Fredman, but of course we can name it, these measures in many words. I mean, like affirmative measures, measures like positive action for women in employment or in elections, or reasonable accommodation measures for persons with disabilities. So all these measures that are required to undertake to be used as some positive steps in order to ensure equal progress of human rights for all discriminated groups. So what I would really like to have here is more to put on the table this kind of approach. I mean, in the sense as we have, for instance, in the preamble to Protocol 12 of the European Convention on Human Rights. So of course, it's not the perfect, this provision, but it's still about that non-discrimination principle does not prevent states, or I would really say it could be even more inviting states to use this kind of measures to promote substantive equality. So these are my some thoughts on the topic. Thank you once again for having me here.
Thank you very much. Thank you very much also for this insight just on one provision. We see with these two approaches to this project that it's a matter of how complete you want to be, and also when you deal with one provision, one principle, how deep you want to go to take into account all the evolution, the case law and so on. And probably this will be one of the major challenges in this project, to find the right balance between all these difficulties. Thank you very much, because that's really very useful. We have now the pleasure to listen to Ralph Kessner. As I said, he's the head of unit for fundamental rights and values and rule of law at the Council of the EU. You have also in his CV what he has done before, but in a matter of timekeeping, I will restrict any further remarks on his path, curriculum. But I think he will bring us something very important on the political also efforts by the Union and the member states' government to protect fundamental principles. Ralph, you have the floor.
Well, thank you very much, ladies and gentlemen. It's an honor to be here, distinguished audience. Where I come from, deep inside the Brussels bubble, really. Council Secretariat, our team basically assists the discussions of member states on rule of law issues over the last years. So I cannot talk here. I can also only offer you some personal thoughts, no official council position, no council presidency position. This is just off the record and Chatham House, basically. Still, it's always a pleasure to get out of the bubble. So here, we are talking about the holy grail of the whole Western civilization now. Fundamental constitutional principles of the Union, Article 2 of the treaty. There's a big project that tries to define all of this. The court in Luxembourg is quite active. So on the legal side, I think I'm pretty confident that we will know what is in there and how to handle it. Yeah. I want to have it here more today on the political side. How does the Union protect these values in a political manner? And there I can only offer, well, I would like to offer three thoughts. There's one on why it's not so easy for the Union to respond to these challenges. Two, that the Union has started to create some solid response or policy in this area. And three, that this is not a static area, certainly not. And also it will still move a lot. So the first thing is basically why it's not easy for the Union to respond to these challenges. And because I think back 15 years ago, EU 15, NATO, tightly knit family, rule of law, democracy was firmly in national sovereignty realm. No, the Union has had no discussion whatsoever on these issues, never. Not in the Council, not in the Commission. This was only in the accession process. Now in the last years, this has clearly moved to the top of the political agenda of the Union, because member states are fully aware that without a rule of law, without the principles of a liberal democracy, you just can't maintain the judicial area, you can't maintain the internal market, and you can't maintain any foreign policy credibility to the outside world. So there's an intense political battle going on, or it is still going on in Brussels over how to protect these values. And I always thought it's interesting that the legal side is, to me, fairly straightforward, because I think the court in Luxembourg is ready to define perfectly ambitiously also what is meant and how to protect it. The problem is, why can't we really enforce these rules as easily as it seems? Yeah, because these are clear violations. So why is it not happening? Yeah, where's the problem? And I think ultimately it's because we have established legal frameworks to handle certain issues in our democracies, but these attacks transcend these legal frameworks. You cannot just rely on the legal frameworks to resolve these issues. It's not like an antitrust violation where you have a legal analysis and you come to a conclusion, it's a fine or it's no fine, and there's a review or no review. This is highly politically sensitive here. You have democratically elected governments to whom this is extremely sensitive. Yeah? If you attack them on this issue, it's a matter of the Prime Minister office, and not only of courts and let's say technicians in this case. So in addition, the Union has a big problem, of course, governments don't like to put each other on trial in the Union. They sit together every day of the week. They have to cut a deal on energy, on inflation, on Ukraine, and it's just not easy then to put somebody on the hot seat if an hour later you have to somehow cut a deal on energy prices. Yeah, this is it's not easy to handle these things. And if you look at the US, it's not so much better. If you look at the January 6 hearings, you could also say, wow, it's fairly straightforward what happened, so why don't you act? Where's the enforcement? And our liberal democracies, they just don't find it easy to attack these sort of attacks, to respond to these sort of challenges. So anyway, I would just say that it's fairly, the Union has become more serious about this. Also, the governments certainly have. The criticism is abundant of why that the Union is responding too weak, too slowly. It's never good enough. But it hasn't done such a bad job if you look at it, to take once the big picture. First line of defense, the court in Luxembourg, has fully risen to the occasion, I would say, has clearly sensed the threat, has said the effective legal protection that member states have to offer, in fact, encompasses the entire rule of law principles. It basically means you can enforce them. It has also said in the spring, in a landmark ruling, really, that the values in Article 2, they are the legal identity of the Union, and they must be defended. You can defend them if you want. And what's the last point they said? Give me a second. That it's a condition for the enjoyment of all rights of the treaties to respect these values. And that is landmark constitutional law, what the court has set out there. Yeah? So the court, very good, but unfortunately the real battle is political about these values. This is a political battle about the soul of the union in a sense, and how to enforce these principles. And so what have member states agreed to do now? Well, as you probably have heard in the newspaper also, there's Article 7 proceedings going on concerning Poland and Hungary, where the union or the council can determine that there's a clear threat to of a serious breach of these values. It's probably not the sharpest knife in the drawer, yeah, but it's ministers discuss perhaps 4 times a year these procedures and spend a lot of time on this. Mark the fact that they are attentive to these developments and discuss them. I think it's a political process. It's not a legal process. So that's why the results are perhaps not so convincing also, always. Then every year now there's an annual dialogue among ministers on rule of law issues based on a fantastic commission report. Very extensive on rule of law in the 27 member states, a snapshot. Ministers now roughly 3 times a year spend time to discuss the horizontal situation in the union and 10 member states. Also shows that trust is beginning to develop. You clearly sense in these meetings that we accompany and assist, there's more and more appetite of member states governments to discuss this, to trust each other, they are ready to talk about it, which they were not 10 years ago. I think the last and the sharpest knife in the drawer now is the link to the budget. The conditionality regulation, the fact that there is now a law that says if you want the money from the EU budget, you have to respect the rule of law values. So there's a tense political battle going on at the moment. The court has green-lighted this, but the political battle is raging on whether, in this case, Hungary and Poland would be entitled to access the billions that are set aside. And that's where you have leverage, of course, in the union. Huh? So overall, I think if you take the zoom out, and you can state that the union has taken a lot more control over national rule of law and democracy issues, as was the case 10 years ago. And that is not satisfying to everybody, of course. Everybody wants more. But if you look back at this is how the union works as a political actor. Yeah? You have the financial crisis in 2008. No member states before was ready to submit its national budget plan to the union. Now they all do, because the European semester has been created, and it's not perfectly enforceable, but it forces everybody to talk to each other, to exchange information, and it does create the dynamics you need to keep the project running, let's say. So I think that would take me now to the last point that I said. It's not static. Everything is moving, and certainly in the political, at the political level, this new policy, let's say, of the union in the area of rule of law is there to stay. You have enlargement coming. You have a whole list of countries that want to come in, and there will be some deal will be struck in the next 10 years, and it will be a big deal, of course, to make sure that once they enter, the standards, the values of the union, the Holy Grail will be protected. But at the same time, it's also not static, because the union every day has to strike deals between all the things that shape our lives. The energy prices, the Ukraine war, inflation, China, and trade, for instance. So in all this, you have somewhere also the values, and it's never satisfying. I mean, nobody will ever get the whole package. It's always a deal. And so on the political side, so it's not static. Second, I think on the legal side, it's not static either. If the court now says that if you the respect for the union's core values is the condition for the enjoyment of all rights deriving from the treaty, this opens up a huge possibility for the union to act if they decide to do so. Basically, the court has weaponized the values. They have said, here, you want to act, you can act. You take the values and you do what, if you're ready to act, please act. And so I think that's encouraging too, that the court has created the ground to do more if the member states decide to do so. So in conclusion, I think I would just overview these three things. One, the Union has probably gotten more serious about the toolbox it has to respond to these challenges to its values. Second, that this is far more a political battle than a legal battle in the end, because it's so complicated to square the circle. And three, it's extremely fragile. Yeah, everybody changes its mind, politicians, voters, and even good lawyers sometimes change their minds, as the US Supreme Court has shown. Yeah, so there's extreme fluidity. Thank you.
Thank you very much. Thank you very much to Ralph Kessner. Also, because during this week, I had a discussion with someone who said that maybe fundamental rights are just political and not legal. And that was linked also to the lecture we had at the beginning of this conference. So it's not just squaring the circle or circling the square, but also coming back to what we had at the beginning of the week on the role of the judge, and whether the judge should act as a legislator or not, stop at political aspects or be purely legal, if I can say. And obviously, constitutional law is a battlefield that is certainly not just legal, but politically, as you beautifully showed. I think these were also very important thoughts. Now, time is running, and of course, lunch is approaching, which is a good news. But so we have about 15 minutes to take a couple of questions, and then I will hand over to the speakers to react and say a final word. So please, I see one here, one. Okay. Who? No, it was Matthias Storme, I think, the first one. Thank you. Yeah.
Dear President, dear speakers, I was told that at the council meeting of the ELI, some people suggested that sometimes, in order to have critical debate, we should have an advocatus diaboli. So that is a role which I always
That's why we invited you, no?
That's why you?
That's why we invited you.
Precisely. And, well, there are some fundamental contradictions in the whole project, evidently. Liberal democracy, as the document starts to say, is an ideology, which means that there may also be other ideological conceptions of democracy that cannot be called liberal democracy, maybe. Is it the task to choose one ideology? There's a contradiction between, let's say, celebrating the principle of political pluralism, but in a sense say, we are pluralistic, but only unless you share our values. If you have other values, there's no place for you in pluralism. There are some clear ideological choices that are made. And there is the contradiction between some of these choices and the concept of democracy, which is evidently an eternal problem, a very difficult problem, I know, but our colleague Tidima said regression is possible. Well, I can ask the question, and then afterwards I have one more sentence and I will stop. I can ask the question, is a shift of power from elected parliaments to unelected judges not precisely a regression in democracy? I would consider, with my remembrance of the French Revolution, was made to fight against the parliaments in the sense of courts, whereas of the equity of the parliaments were the courts in France, not the elected parliaments. Now, I can apply that to many of these principles. I will not do that, evidently. I would overgive. But just to take one example, Principle 7 on disinformation. We start with freedom of press, but then we call for fighting disinformation. Who is going to decide which information is false and which is true? The whole freedom of the press is precisely because it's not for the state to decide that. Moreover, the principle even calls for private censorship by big companies. How can you rhyme this with the other principles of freedom of speech and freedom of press? There's too many contradictions because it's too much an ideological document which is not limited to those things where across different political ideologies you have a consensus. And we should limit us to that.
Thank you very much. Further questions? So here in the middle.
I'm Yavuz Aydın, and I want to just focus on this, having heard about this freedom of expression and role of judges a couple of days ago and today, based on my background, I want to focus on this freedom of expression of judges a bit more, because I'm one of the 4,000 dismissed judges in Turkey in 2016, and now I'm living as a refugee in Belgium. And by the way, I'm a refugee of Romania living in Belgium. We talked about, talking about this fundamental constitutional principles. In liberal democracies, we said that this checks and balances, though there are exceptions like the UK, checks and balances is vital. This checks and balances system is vital. So in this tria politica, there is this judiciary as well. So if the source of legitimacy, that's also interlinked with your question, so if the source of legitimacy is only being elected, if the votes are the only this whole source of legitimacy, how will judiciary function its duty to in this checks and balances system? Now that we have this Baca versus Hungary decision of the ECHR, and more recently, my close friend from Poland, Waldemar Zurek versus Poland in 2021, and Kozan versus Turkey 2022 this year. So it's clearly stressed out by the ECHR that it's not only the freedom of expression for the judges to defend the judicial independence, but it's also the duty of each and every judge to defend judicial independence. So are you planning to focus a bit more on this aspect of freedom of expression for this checks and balances system for a liberal democracy? Thank you.
Thank you very much for this excellent question. I had here in the front with the mic.
Well, I repeat my name, Medina Ortega.
Yeah, please.
And you know me, but many people don't know me.
Yeah.
And I think I have to intervene here because I have been for 30 years member of the Spanish Parliament, for 5 years, and 25 years of the European Parliament. And of course, I'm sorry, Mr. Professor Tridimas, I didn't recognize you last night when you asked me about the place to have the meeting, but I have read all your works. So we are in very good hands with Professor Tridimas. It is not true that there is a contradiction between democracy and rule of law. As a member of the European Parliament, responsible in many cases of the European Union law problems, we have used the Court of Justice to strengthen democracy. The Court of Justice is a good instrument to promote democracy. Even when we did not like decisions taken by the Court of Justice, for the European Parliament, that was a very good system. And I had many cases in which we had in contradiction with the court, but the court came out with the right decision, and we, as a general rule, we had to follow it. So there is no contradiction between democracy, the rule of law, division of powers, and the exercise of power by the European Court of Justice. I think it's very important, this kind of thing. And I think it's very important that an institution like this underlines the importance of these two principles, democracy and the rule of law, as interpreted by it. And of course, we are in very good hands because Professor Tridimas has dedicated his life to this issue. And as you know, I know he has a problem of the embarras de choix, what to do. And I think I don't know how, but I really trust him. I think that we could trust him that he probably will direct it in such a way that will be understandable for everyone, and at the same time to highlight the areas where there are problems. So I hope that you can continue with this work.
Thank you very much. I don't see further questions, and given the time, I suggest that we begin. Maybe Takis, you may begin, and then I will ask the other panelists if they have something to add. Maybe that's the easiest.
Sure. Thank you very much. I'm immensely grateful for all the comments. They really are extremely useful. I will not be able to address all of them, but let me take some selectively. And perhaps if I can start from the reverse order, taking the comment that was made, the penultimate comment, or rather the third from the end, about liberal democracy being an ideology. Yes, I think that is correct. Liberal democracy is an ideology. I think when you have a system of governance, you need to make some fundamental choices. There has to be a constitutional identity. And there are many, okay? You cannot be both a theocracy and a democracy. You have to choose whether you are a Creon or you are an Antigone. And people ultimately can choose that. Even when you have an eternity clause in a constitution, the constitution can change. It will be a new legal order. I think what we are saying is, if a polity wishes to claim that it is a liberal democratic polity, these are the anchors on which the legal system should be based. And I entirely get the point that there are many dangers, there are many risks, and you can have too much judicial activism. I followed the discussion yesterday, although it seems to me that the discussion about judicial activism occurs at a level of abstraction that hides the degree of disagreement. I think that a lot of it is common sense. I don't think there is any doubt that if you take a group of judges, those that sit in the Supreme Court of the United Kingdom or Strasbourg, and you ask them to decide a set of facts according to the law of Iran, they're probably going to come up with a different outcome than if they apply the European Convention of Human Rights. There are limits into what judges can do. I think the idea of and there are certainly contradictions among the principles, yes. That is why we need balancing. This is why we need a process. This is why we need strong institutions. So, and I have no objection to saying, well, the court got it wrong in this case. I made my living out of criticizing others, really, especially courts or arguments of other parties. What I think is problematic is when we elevate the critique to one of legitimacy. If we say that this is no longer a legitimate institution. So, yes, it has an ideological posture. I don't think we can avoid that. We need to work on. We can't have principles unless we have certain anchors. So, if we take liberal democracy as the regime we aspire to, then it seems to me that these principles ought to apply. But I'm very happy to enter into more discussion. On the actual principles, look, I don't have time to go through all of them. I note the points about non-discrimination. It is a matter of, and I will discuss it with the group. Of course, determining the appropriate level of specificity is always problematic in those projects, because once you start singling out a particular form of discrimination, you would need to justify why you do it, or then you would need to, you would be open to the critique, why did you not have a specific clause on race discrimination, and so on and so forth. But I take all the points, and I think some of them can be accommodated more easily than others. I'm grateful to Judge Costello for all the points. I note in particular the point about smear campaigns it also links, I mean, disinformation also links with micro-targeting of voters. And again, I entirely take the point. What is disinformation? What is illegal contact, as the Digital Services Act talks about? But unfortunately, that's why we need institutions. That's why we need a process. We need good judges. We need a thorough process of adversarial exchange of arguments, and we hope to get as much as we can to the truth. So really, what we say right at the beginning is that there is no suggestion that this is the only regime. The underlying premise is that it's as good as we can get by having these principles. I will leave it here, and I can take perhaps privately other comments. Thank you very much.
Thank you very much, Takis. Judge Costello, you have 1 minute if you want to add something or to react also of what has been said by the audience here.
Thank you very much. I very much appreciate and agree with the response already given by Takis. I mean, obviously, liberal democracy is an ideology, but it's not any kind of ideology. It's one that has been adopted in the domestic constitutions as a very foundational basis of those constitutions. It has been at the European level established as the basis of the European Union and the membership in it, and in the already back in the times when the Council of Europe was founded, it was recognized that individual freedom, political liberty, and the rule of law form the basis of all genuine democracy. I mean, a genuine democracy does require the checks and balances and the institutions charged with upholding the basic principles. That it is extremely difficult and complex and requires all sorts of balancing is obvious, but really these are the really foundational principles we have all agreed on at the European level jointly, and this is why it is important that we do all we can to uphold those principles. There is no contradiction between democracy and the rule of law. On the contrary, they are closely interlinked. You cannot have one without the other. This is all I wanted to say. Thank you very much.
Thank you very much. Do you want to add something? You're allowed to.
Thank you. Just a couple of quick remarks. Yes, of course, I think liberal democracy has been the ideology of choice since the Second World War, and since everything that came after with NATO and the Council of Europe. This was a driven concept now enshrined in all our constitutions, also in the European Constitution. And second, the absolute democracy and rule of law are intertwined. You can't separate them because you can't have rule of law without democracy. And the last point is, of course, the role of the judge in this setup has always been a little bit difficult because he's supposed to be independent, but at the same time, he has to respect the rules. So yes, Van Rent and Loos has been absolutely transforming as a judgment, and perhaps could have been totally different, the history of Europe without. But sometimes judges do render these judgments, and they have a tremendous effect. And yes, as long as they respect the framework within which they are supposed to act, that's fine. But still, it has to pass also somehow the test of the political acceptance around this. Only if the entire apparatus around it is ready to accept this sort of jurisprudence and determined to move ahead on this basis, then it will work. And sometimes it works, sometimes it doesn't. It's a strange...
Thank you very much. Maybe just to close this panel, a couple of further words. First of all, I just wanted to mention also Elise Muir, She's co-reporter on this project, and also the two chairs or co-chairs of the project, Sir Francis Jacobs and Sir Geoffrey Jowell, so that, you know, to show that this is under a larger umbrella, if I may say so, and also to underline the fact that some of the points that were addressed, for instance, the freedom of speech, have been the object of the common constitutional tradition. So, of course, we do not want to reopen, when I say we, the European Law Institute, but of course, this is also for the co-reporter to decide to what extent they want to go into these aspects. But we open a project that has come to an end. And the same for the judicial independence, which is a project in itself for obvious reasons, so that here there are also not check and balances, but balances to find. And coming from a country where judges are elected, of course, I think we are in the center of democracy. Switzerland, of course, is not only a representational democracy. Thanks to the referendum, there were some remarks on referendum. Of course, the way the Swiss treat referendum is pretty much different, and but I won't speak about referendum right now. What I want to say is I found this panel very instructive. I thank all the panelists and, of course, the co-reporter as well for the insightful and provoking thoughts as well. It gave us a kind of overall understanding and challenging aspects so that everyone can have something to discuss. And thank you for being here.